Welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies they're creating. This podcast delves into a diverse range of subjects encompassing finance, law, mental and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out on social media or leave a comment. Your input fuels the conversations we have. You can find all of our episodes on YouTube, Spotify, and Apple Podcasts, so make sure to subscribe and stay tuned for our upcoming content. We would really appreciate you following the podcast and leaving us a 5-star review. Your 5-star review will amplify the podcast and get it out to more people. Now, on with the podcast. Today's episode is Navigating Probate Costs, 6 Factors and Solutions. Let's dive into the factors that contribute to increased probate costs and explore potential solutions for each. Let's go. Number 1, disputes among beneficiaries. Disputes among beneficiaries is a common factor that contributes to an increase in probate costs. When disagreements arise regarding the distribution of assets or, say, the validity of the will, if there is one, the probate process can quickly become contentious and expensive. Beneficiary disputes often lead to lengthy legal battles, with each party retaining legal representation to advocate for their interests. These disputes may involve challenges to, as I said, the validity of the will, allegations of undue influence, or arguments over the interpretation of estate documents. As litigation proceeds, legal fees accrue and court costs rise, placing a significant financial burden on the estate. Additionally, prolonged disputes can result in delays in the final resolution of the probate process, further increasing costs and prolonging the emotional strain on all parties involved. Let's look at an example of how this plays out. Jane's passing has led to the inheritance of a valuable estate. However, disagreements have arisen as daughter Emily has raised concerns about the validity of the will, citing alleged undue influence from son Michael. This has resulted in legal disputes between the siblings, leading to the hiring of attorneys and the accumulation of fees and court costs. The probate process has been delayed as assets are tied up in litigation, depleting the estate's resources. The prolonged legal process has reduced the inheritance set aside for Emily and Michael, straining their relationship and emotional well-being. Eventually, a settlement is reached, but the financial impact on the estate is significant, emphasizing the importance of proactive conflict resolution and sound estate planning to avoid costly disputes. Number 2, complex or contested estates. Complex or contested estates pose multiple challenges that can significantly increase the complexity and cost of probate. Estates with intricate asset structures, such as multiple properties, businesses, or investment portfolios, require thorough valuation and meticulous asset distribution. Determining the fair market value of diverse assets often requires the involvement of appraisers, financial analysts, and other experts, which adds to the overall expense of probate administration. Moreover, contested estates where beneficiaries or other parties challenge the terms of the will or assert competing claims to estate assets frequently lead to contentious legal proceedings. These disputes may necessitate extensive litigation, expert testimony, and mediation efforts, thereby raising legal fees and court costs. Consequently, administering complex or contested estates can consume significant resources and prolong the probate process, resulting in substantial financial burdens for the estate and its beneficiaries. Let's look at an example of how this point plays out. When a prominent businesswoman named Sarah passes away, her estate, which includes multiple properties and various investments, faces challenges. In her will, Sarah names her 3 children as equal beneficiaries, but disagreements arise over the distribution of assets. Sarah's oldest son, David, disputes the will, claiming that Sarah had promised him a larger share. Legal proceedings are initiated, requiring the involvement of professionals such as appraisers and financial analysts to accurately assess the value of assets. Both the estate and David vigorously defend their positions, causing legal court costs to rise and depleting the estate's resources. The probate process is delayed as court battles prolong the resolution, leading to further increased expenses. Eventually, a compromise is reached, but not without significant financial strain on the estate and emotional turmoil within the family. This scenario illustrates how complex or contested estates can result in prolonged probate procedures, substantial financial burdens, and strained familial relationships. So let's distinguish the 2 examples we've discussed so far. The example provided earlier illustrates disputes among beneficiaries, while this new example focuses on the complexities and challenges of administering a complex or contested estate. In the previous example, the primary conflict arises between beneficiaries Emily and Michael regarding the validity of the will and asset distribution. In slight contrast, this example portrays a scenario where the estate itself, due to its intricate asset structures and potential disputes over asset distribution, becomes the source of contention. The disputes may involve beneficiaries, creditors, or other interested parties, leading to contentious legal proceedings, escalating costs, and prolonged probate processes. While both examples highlight the significant financial burdens and emotional strains associated with probate, they differ in the specific circumstances and parties involved in the conflicts. Let's move on to the third point. Lack of estate planning. The absence of estate planning documents, such as wills and trusts, can significantly complicate the probate process and escalate costs. Without clear instructions from the deceased regarding asset distribution, the probate court must rely on state intestacy laws to govern the disposition of assets. Intestacy proceedings can lead to lengthy delays and administrative complexities, as the court endeavors to determine rightful heirs and allocate assets accordingly. To mitigate these risks and streamline the probate process, individuals are encouraged to engage in comprehensive estate planning, including the establishment of wills, trusts, and other legal documents tailored to their specific needs and objectives. The fourth point, creditor claims. Creditor claims against the estate are a significant source of potential liability that can increase probate costs and reduce the assets available for distribution to beneficiaries. When the decedent passes away, creditors have the right to make claims against the estate to pay off debts owed by the deceased. Personal representatives are responsible for identifying and resolving valid creditor claims, which may involve negotiating settlements, challenging disputed claims, or selling estate assets to satisfy debts. Resolving creditor claims can be a time-consuming process that requires detailed documentation and legal expertise. Failure to address creditor claims adequately could lead to legal action, seizure of estate assets, or personal liability for the personal representatives, adding to the financial strain of probate administration. The fifth point, out-of-state property. Estates with property located in multiple jurisdictions may face complex legal requirements and procedural hurdles, resulting in higher probate costs and administrative burdens. If a decedent owns real property or assets in states or countries outside their primary residence, ancillary probate proceedings may be necessary to transfer ownership and settle estate matters in each jurisdiction. Ancillary probate entails initiating separate legal proceedings in every location where the decedent owned property, which could involve hiring local attorneys, submitting additional court documents, and adhering to distinct procedural rules and regulations. The replication of efforts and the necessity to coordinate with various legal jurisdictions can significantly prolong the time, costs, and complexity of probate administration, diminishing the estate's overall value and postponing the distribution of assets to beneficiaries. Let's look at point number 6, delays in asset identification and valuation. Delays in identifying and valuing estate assets can lengthen the probate process and increase administrative costs. This happens as personal representatives struggle to compile accurate inventories and assess the fair market value of diverse holdings. Personal representatives have the responsibility of identifying all assets owned by the deceased person, which includes real property, financial accounts, personal belongings, and business interests. Valuing assets often requires the expertise of appraisers, financial analysts, and other professionals to determine the current market value and assess potential tax implications. Delays in asset identification and valuation can hinder the timely distribution of assets to beneficiaries, extending probate proceedings and requiring ongoing oversight by the personal representatives. To expedite the probate process and reduce costs, personal representatives should prioritize the prompt identification and valuation of estate assets, utilizing professional expertise and technological tools to streamline administrative tasks and ensure accuracy. Now that we've explored the factors contributing to increased probate costs, let's discuss proactive solutions to mitigate these challenges. Number 1, comprehensive estate planning. Engage in thorough estate planning while you are still alive to ensure that your assets are organized and distributed according to your wishes. Work with experienced estate planning attorneys to draft wills, trusts, powers of attorney, and advance directives tailored to your specific needs and objectives. A comprehensive estate plan can help minimize potential disputes among beneficiaries, streamline asset distribution, and reduce the likelihood of costly probate proceedings. Number 2, regular review and updates. It's important to regularly review and update estate planning documents to reflect any changes in personal circumstances, family dynamics, and financial situations. Make sure that wills, trusts, and beneficiary designations accurately reflect your current intentions and preferences. By being proactive and keeping estate plans current, individuals can avoid potential discrepancies or disputes that may arise during probate. Number 3, asset organization and consolidation. Organize and consolidate assets to simplify the probate process or avoid it altogether and minimize administrative complexities. Consider consolidating accounts such as bank accounts, investment accounts, and retirement accounts to streamline asset management and facilitate asset distribution. Additionally, explore options for transferring assets into trusts or other legal entities to avoid probate altogether for certain assets. Number 4, beneficiary designations and joint ownership. Where appropriate, utilize beneficiary designations and joint ownership arrangements to transfer assets directly to beneficiaries outside of probate. Assets held in joint tenancy with rights of survivorship or tenants by the entireties, payable on death accounts, and transfer on death designations bypass probate and transfer automatically to designated beneficiaries upon death. By designating beneficiaries and establishing joint ownership arrangements, individuals can expedite asset transfers and minimize or eliminate probate costs. Number 5, asset protection strategies. Implement asset protection strategies to shield assets from potential creditors and legal challenges. Explore options such as asset protection trusts, irrevocable trusts, and life insurance policies to safeguard assets and minimize exposure to creditor claims. By proactively protecting assets, individuals can reduce the likelihood of costly litigation and preserve assets for intended beneficiaries. Number 6, open communication and family discussions. Foster open communication with family members and beneficiaries to discuss estate planning intentions, clarify expectations, and address potential concerns. By proactively discussing estate planning decisions and intentions with loved ones, individuals can minimize the risk of misunderstandings, disputes, and legal challenges during probate. So to sum it up, navigating probate costs can be complex. However, understanding the factors that contribute to increased expenses and implementing proactive solutions can help alleviate financial burdens and streamline the process. By addressing potential sources of contention, such as disputes among beneficiaries or complex estate structures through comprehensive estate planning and open communication, individuals can minimize the likelihood of costly probate proceedings. Additionally, organizing assets, utilizing beneficiary designations, and implementing asset protection strategies can further mitigate expenses and ensure efficient asset distribution. It's important to remember that regular review and updates to estate planning documents are crucial for adapting to changing circumstances and preserving assets for intended beneficiaries. In conclusion, navigating probate costs can be complex. However, understanding the factors that contribute to increased expenses and implementing proactive solutions can help alleviate financial burdens and streamline the process. By addressing potential sources of contention, such as disputes among beneficiaries or complex estate structures, through comprehensive estate planning and open communication, individuals can minimize the likelihood of costly probate proceedings. Additionally, organizing assets, utilizing beneficiary designations, and implementing asset protection strategies can further mitigate expenses and ensure efficient asset distribution. It's important to remember that regular review and updates to estate planning documents are crucial for adapting to changing circumstances and preserving assets for intended beneficiaries. If you're in Maryland or the District of Columbia, and if you're seeking guidance on navigating probate or estate planning, we invite you to book a complimentary 15-minute call with a member of our team. Take proactive steps today to safeguard your legacy and provide peace of mind for the future. Thank you for joining me on this episode of Wills, Women, and Wealth. Until next time, this is Attorney Elsa W. Smith, your Maryland estate planning and probate attorney. Stay informed, stay empowered, and take control of your legacy.